7 things every injured worker in South Carolina needs to know right now, but often they don't until it's too late. The workers' compensation system is here to help you. Here is how to make sure it actually does. Hi, I'm Brent Stewart, South Carolina workers' compensation attorney, and today I want to share 7 tips that can help protect your claim, your health, and your paycheck. The workers' compensation system was designed to help people that were injured on the job, and in theory, it is straightforward. You get injured, you report it, you get medical treatment and wage benefits while you recover. But in practice, it's not quite that simple. There are deadlines that can erase your rights if you miss them. There are decisions made in the first few days that can shape your entire claim. And there's an insurance company on the other side that wants to pay out as little as possible. I've seen too many people lose benefits that they're entitled to, not because their injuries weren't real, but because they did not know the rules of the system. Today, I want to change that. These are 7 tips that every injured worker in South Carolina needs to know. And stay till the end because number 7 is worth more than all the others combined. Tip number 1, report your claim immediately and in writing. This is where most workers' compensation claims go wrong before they even start. You get injured on the job, you tell your supervisor, and they say something like, well, let's just see how it goes, or take it easy for a few days. And while that conversation can protect you and provide notice, it's better to have it in writing because then there's no dispute later as to what was said or how you reported the claim. In South Carolina, you have 90 days to report your workplace injury to your employer. Miss that window and you can possibly lose your rights to benefits forever. And despite the legal implications of not reporting within 90 days, the longer you wait, the harder it is to prove that your injury occurred on the job. So report it in writing immediately. Send an email saying you're injured. And if your employer wants a written accident report filled out, please talk to a workers' compensation attorney first. Anything that creates a date, your name, and a description of what happened, because a verbal conversation can be denied later. But a written report is evidence, and evidence is what wins workers' compensation cases. After you've reported the injury, the next step is to get medical attention. See a doctor and tell them that it's work-related. In situations where the employer asks the injured worker to put it on their health insurance and say it's not work-related, later I've seen those claims denied. You may want to help your employer and go to the doctor saying it's not work-related so your health insurance covers it. But if that injury becomes more serious, then you're stuck with a situation where they're going to deny the claim based on that medical evidence. So when you see the doctor, you need to tell them 2 things. First, tell them exactly how the accident happened, like as specific as you can. For instance, on Tuesday, I was lifting a 50-pound box and felt a sharp pain in my shoulder. Second, you need to tell them it's work-related. Those words need to be on the medical record. Why does that matter so much? Because your medical records are the foundation of your entire claim. The insurance company's first move is to look at what the doctor wrote. If the medical records document back pain, but no mention of work, the insurance company may argue that the injury did not happen on the job. But if the report says the patient complains of back pain after lifting items at work on a specific date, that connects your injury to the job day one. In South Carolina, the employer generally picks the medical providers, but the information you provide the medical providers is within your control. So be specific, be thorough, and make sure the connection between the injury and work is connected. Tip number 3, do not sign anything without understanding it. After a workplace injury, there's usually paperwork. The employer gives you forms, maybe the insurance company sends you documents, and in the confusion and pain of the first few days following the accident, some people just sign them. That can be a serious mistake, but others may limit your rights in ways you don't understand until it's too late. For instance, there may be a form that acknowledges a series of events that simply did not happen. There may be a release that, if signed, restricts your ability to make certain claims. There may be language that waives rights you may not even know you have. So, before you sign anything, read it carefully. And if you don't understand what a document says, do not sign it. You have the right to take it home, review it, and ask questions. And if anything seems off, you have the right to talk to an attorney before putting your name on that document. Nobody should feel pressured to sign a document while they're injured and overwhelmed, because your signature is permanent and so are the consequences. Tip number 4, follow your doctor's orders exactly. I know this seems obvious, but I cannot stress it enough. If your doctor says, do not lift over 10 pounds, don't lift 15. If they tell you to go to physical therapy 3 times a week, go 3 times a week. And if they tell you to stay home from work, stay home. Here's why this matters in the context of workers' comp. The insurance company is watching. Not literally, but they are tracking everything. They'll review your medical records, they'll check whether you attend appointments, and in some cases, they will hire investigators to follow you to see if your complaints match up with your actual behavior. So, if your doctor says you can't bend or lift, and if the insurance company gets a photo of you carrying groceries into your home, they might use that to argue that your injuries are not as serious as you claim. And even if you just grabbed a gallon of milk and your shoulder hurt the entire time, the picture may tell an entirely different story. Following your doctor's orders exactly protects your health and your claim. So, even if you disagree with your doctor's orders, do not ignore them. You can speak to an attorney about getting a different physician or a second opinion by going through the proper channels. Tip number 5, know your benefits and do not leave money on the table. A lot of injured workers don't understand what workers' comp covers. And because of that, they miss out on benefits that they are actually entitled to. In South Carolina, workers' compensation generally covers 3 main things. The first is your medical treatment related to the injury: doctor's visits, surgery, physical therapy, medications, prescriptions, and other medical things directly related to the work-related accident. You should not be paying out of pocket for medications or other things related to a workers' comp injury. Second, wage replacement. If you're unable to work, you're typically entitled to 2/3 of your average weekly wage up to the state-provided maximum benefit. And if you're only able to work light duty and not make the wages you were before, you may be entitled to partial benefits. Third, and this is the one people miss most often, permanent disability benefits. If your injury leaves you with a permanent disability, you may be entitled to additional compensation based on that impairment. This is assessed after you reach what's called maximum medical improvement, and it needs to be put out in writing by your doctor. Many people settle their cases without actually getting an impairment rating. They leave that money on the table because nobody told them that right exists. Do not let that happen to you. Make sure that every benefit that you're entitled to is on the table before you agree to any settlement. Tip number 6, don't let your employer push you back to work too soon. I know there's a lot of pressure to get back to work after a workplace injury. Coworkers are covering shifts and you need the income. I get it. But going back to work before your doctor says it's appropriate can be one of the most damaging decisions to both your claim and your body. Here is what might happen. You return to work on light duty, but the work you're given is really not light duty. You're still lifting, you're still bending, you're standing for hours, and your injury gets worse. Now the insurance company may argue that the worsening is not caused by the initial injury. It's caused by you going back to work. And suddenly your claim is complicated in ways it didn't need to be. Your doctor is the one that clears you to return, not your employer and not the insurance company. That clearance should come with specific written instructions. And if your employer does not have a job that fits your restrictions, you still may be entitled to wage benefits. Returning to a job that makes your injury worse is just not worth it. Tip number 7, get an attorney involved early. I save this for last because it's a tip that I think makes the biggest difference. And it's the one that most workers' comp claimants wait a little bit too long to act on. People think they can handle the claims themselves, and they only call a lawyer after the claim went sideways. But by that time, the damage may already be done. You've given statements, you've gone to a doctor without an attorney monitoring the treatment and the way you're being treated, and you've missed out on benefits that you did not know about. An attorney can step in from day one and handle everything. We can deal with the insurance company so you never have to. We can make sure that your medical treatment is appropriate and your restrictions are appreciated. We'll track the deadlines and identify every benefit you're entitled to. That way, when we settle, we can make sure the number represents the true value of your case. And just like with personal injury cases, workers' compensation cases are handled on a contingency basis. That means you do not pay anything up front. We get paid a percentage of what we recover on your behalf. So if we don't win, you don't owe us anything. There is no financial risk to getting a consultation, but there is a risk in waiting. The insurance company gets farther ahead with every day that goes by. So if you're dealing with a work-related injury in South Carolina, the smartest thing you can do is pick up the phone and call somebody with knowledge of the system. I'll run through all 7 tips one more time. 1, report your injury immediately and in writing. 2, see a doctor and make sure they document it as work-related. 3, don't sign anything without understanding it. 4, follow your doctor's orders exactly. 5, know all of your benefits and do not leave money on the table. 6, don't let your employer push you back to work too soon. 7, get an attorney involved early. If you're watching this and you've been hurt at work, don't assume it's too late. Even if a lot of time has passed and some mistakes were made, there still may be options available. The longer you wait, the harder it becomes. So click the link in the description for a free consultation.